It's surprising that there were unforeseen issues with the Titan sub. Oceangate was fortunate to be protected from damaging lawsuits due to legal obstacles. However, it remains uncertain whether the victims' heirs will receive any compensation. Well before the Oceangate disaster occurred, the CEO of the company, Stockton Rush, spoke highly of the submersible he developed for exploring the Titanic. He dismissed the sophisticated navigation systems used by other commercial submersibles, proudly assembling the final product at Camping World and charging individuals $250,000 each for the 2-mile underwater journey. Despite clear warning signs, 5 individuals were willing to take unconventional risks to witness the Titanic's wreckage. It is evident that they were aware of the dangers involved. These individuals had signed liability documents acknowledging the potential fatality of the trip. Now, as expected, all participants who paid for the journey signed a liability waiver, indicating their agreement to be bound by the laws of the Bahamas in case of disputes. Quote, "Any disputes relating to or arising out of the transaction or this waiver shall be governed by the laws of the Bahamas." The Bahamian court system operates under English common law principles. Whether families can file lawsuits will depend on how the disclaimer is interpreted within the country. The language used in the disclaimer explicitly states that participants are undertaking activities that carry the risk of death. Quote, "This vessel will be under extreme pressure and any malfunction of the vessel while I am on board could result in serious injury or death." It reports that the Titan quote vessel has not been approved or certified by any regulatory body and may be constructed of materials not commonly found in human-powered submersibles. The waiver says the submersibles are also not designed to carry passengers and could become more dangerous in rough seas. And the waiver says those risks cannot be eliminated. Quote, "I understand that such risks simply cannot be eliminated from any operation. The risks include, without limitation, loss of footing, slips and falls on deck, particularly in inclement weather, harm from falling objects on non-passenger vessels, drowning and malfunction or failure of underwater apparatus resulting in death or serious injury." And the participants had to acknowledge the statement as a condition of going on the trip. Quote, "In signing this document, I acknowledge that if I die and hurt or incur property damage during my participation in the expedition, I may be found by a court of law to have waived my right to maintain a lawsuit. In the United States, liability waivers typically cover only cases of ordinary negligence. If a company's actions involve gross negligence or intentional harm, the liability waiver may not apply. Ordinary negligence refers to mistakes resulting from inattention, general incompetence, or failure to maintain industry standards. On the other hand, gross negligence occurs when someone deliberately fails to exercise reasonable care for someone's safety, exhibiting a complete disregard for others' well-being. In this case, there is a possibility that the defendant's actions demonstrate gross negligence. Prior to the disaster, deep-sea exploration specialist Rob McCollum cautioned Rush in writing, drawing parallels to the Titanic's makers and stating concerns about rushing to explore the Titanic. Rush responded via email, expressing his offense at the accusations and dismissing them as baseless. However, McCollum wrote back again in March 2018, suggesting that Rush was potentially exposing himself and his clients to a dangerous situation. It is evident that at least one person, along with former Oceangate employee David Lockridge and members of the Marine Engineering Society, believed that Rush displayed a complete disregard for the safety of others. In 2019, expert Carl Stanley traveled on the Titan and reported hearing cracking sounds in the hull. After the trip, Stanley wrote a letter to Rush expressing concerns about the carbon fiber hull's ability to withstand deep dives. Both Lockridge and McCollum considered the window to be a significant mistake, as it would have been exposed to water pressure equivalent to about 6,000 pounds per square inch, roughly 2 tons of water at that depth. However, in the summer of 2021, Rush revealed that the window was made of plexiglass, and he was confident in its strength, stating that it was 7 inches thick and weighed 80 pounds. Arthur Lobel, a controller and former passenger, reported that during his 2021 voyage, the sub's destabilization bracket, which is responsible for balancing the sub, was hastily reattached using zip ties. Additionally, Mike Reese, a Simpsons writer, experienced communication failures during all 3 of his dives in 2022. Further issues arose in 2022 when the Titan lost control and started spinning in circles near the Titanic wreckage, just 300 meters away. Something happened to the thrusters, rendering the Titan unable to move forward or backward. One of the victims of the Titan disaster was Paul-Henri Nargeolet, a Titanic expert who had collaborated closely with the organization managing the Titanic wreckage site. Jessica Sanders, who leads the Titanic organization, expressed regret for approving Natalie's participation in the expedition. Sanders stated that Rush had assured potential passengers that the Titan sub was way safer than flying in a helicopter, or even scuba diving, or even crossing the street. There is indeed a significant conflict between what the disclaimer stated about the expedition's danger and the confident assurances given by Rush to potential passengers. If Bahamian law supports the disclaimer, it is likely that families will pursue litigation in their home countries, regardless of the choice of law provision. However, the case may not be straightforward, as courts in many countries tend to uphold specific and clear disclaimers. In this case, the disclaimer was quite specific. The facts suggest that Oceangate may have breached its duty to provide a seaworthy vessel for the crew and passengers. During the development of the Titan, Rush initially used an existing vessel called the Cyclops, which was constructed in collaboration with engineers from the University of Washington. The engineers utilized an off-brand PlayStation 3 controller to operate the sub. Indeed, the decision to retain most of the Cyclops design elements for the Titan while aiming for a much greater depth capability raises concerns about the choice of materials and potential design flaws. Rush opted for a carbon fiber cylindrical middle for the Titan instead of titanium, despite carbon fiber composites being known more for their tensile strength rather than compressive strength. This posed a challenge as the pressure at deep sea depths would primarily exert compressive forces on the hull, potentially compromising its integrity. Rush believed that carbon fiber's buoyancy would help the submarine float to the surface without the need for foam layers used in steel and titanium hulls. This decision was driven by cost-cutting measures. However, the lack of foam layers and uncertainty about the carbon fiber's ability to withstand repeated dives created complications. David Lockridge, the former director of marine operations at Oceangate, expressed concerns about the vehicle's testing, potential dangers to passengers, and the likelihood of the carbon fiber hull collapsing at great depths. Lockridge met with Rush and other company executives to outline his concerns and reportedly highlighted additional design flaws, such as the certified depth of the view screen not aligning with the required depth to reach the Titanic wreckage. While private agencies exist to calculate and certify submersibles, Lockridge claimed that Oceangate did not want to incur the costs of independent certification. Subsequently, Oceangate fired Lockridge and filed a lawsuit against him for disclosing confidential information. The company argued that Lockridge, who was not an engineer, was discredited and that their own durability tests surpassed the recommended independent tests. Lockridge was not the sole voice raising concerns about the design of the Titan. Director James Cameron, who has expertise in submersible design and has extensively visited the Titanic, criticized the fundamental flaws in the carbon fiber construction of the Titan. Cameron stated that these concerns were widely known within the deep-sea exploration community, which considered the sub too experimental to carry passengers and emphasized the need for certification. Additionally, 38 members of the Manned Underwater Vehicles Committee of the Marine Technology Society sent a letter to Rush after Lockridge's dismissal, expressing their unanimous opinion that Rush was misleading the public and risking a catastrophic outcome. When filing negligence lawsuits, lawyers need to demonstrate that the defendant either failed to adhere to the ordinary standard of care or knowingly disregarded it. This often involves hiring expert witnesses who can define industry norms and evaluate whether the defendant's conduct met those norms. In this case, experts in the field have asserted that the Titan did not meet industry standards even before the accident occurred. Regarding the legal aspect, although the Death on the High Seas Act, DOSA, initially seems applicable, the classification of the Titan as a vessel under DOSA is not entirely clear. Ironically, Oceangate might be subject to the same exception under DOSA. There are several open questions regarding the legal aspects of the incident, including whether a submersible qualifies as a vessel under relevant laws such as the Ship Owner's Limitation of Liability Act and the Vessel Act. Additionally, determining which jurisdiction's laws would apply is complex due to various jurisdictional issues. Both the United States and Canada have initiated investigations into the Titan incident. Regarding jurisdiction, Oceangate Expeditions is based in Everett, Washington. However, the company ceased its operations in Everett following the accident. The Titan was launched from the Canadian-flagged ship, the Polar Prince. Furthermore, the individuals on board the submersible hailed from England, Pakistan, France, and the United States. The location of the wreck in the middle of the Atlantic Ocean adds to the complexity of determining jurisdiction in this case. In the United States, the Coast Guard regulates passenger carrying submersibles, and submersibles with fewer than 6 passengers are not subject to inspection. This is likely why Stockton's sub carried only 5 people. Regulations specify that an uninspected submersible may be permitted in passenger operations if it is designed and constructed to a recognized industry standard, acknowledging the unique design, operating characteristics, and inherent hazards of underwater operations. However, Stockton Rush classified the passengers as mission specialists and labeled the $250,000 fee as a donation in an attempt to evade the implication that they were regular ticket, buying passengers. Industry experts were aware that Rush was attempting to circumvent these regulations, and they signed a letter urging him to adhere to the rules. The type of tourism they were conducting would not have been allowed in U.S. waters by the Coast Guard, nor would it have been permitted in British coastal waters without proper certification. Similarly, operating in Canadian waters would have required compliance with specific regulations. As it turned out, they operated in international waters where no single Coast Guard has jurisdiction. They seemingly found 2 loopholes, but their approach may not have been wise. Despite the development and construction of the Titan taking place in Washington state, legal filings from the company indicated that the sub would be owned by a Bahamian entity, registered in the Bahamas and operated exclusively outside the territorial waters of the United States. At present, while it is expected that numerous lawsuits will arise, it remains uncertain which jurisdiction will have authority, the status of the Titan's insurance and that of the passengers, and whether the liability waivers signed by the passengers will be enforceable or not. That's all for today. Bye.